Okay, we're going to go on to talking about non-immigrant temporary visas. Would like to introduce formally on the panel June Chang, who's an attorney within the department, and want to just kind of talk initially, about, first of all, what is it we're going to be talking about? What is it we're going to be talking about over the next couple minutes? It's non-immigrant visas, which is basically a class of visas, just for definitional purposes. It's a class of visas that are characterized by two basic realities. Reality number one is temporary visas, as the name implies, is visas that are given for a temporary period of time. Okay, and the period is going to vary depending on what type of visa we're talking about. The second element that defines non-immigrant visas is it is limited in scope. So there are two parameters that are being addressed in the temporary non-immigrant visas. One is a temporal one, how long can someone stay in the United States? And the second is a scope of activity. What can someone do? So someone can be admitted in a visa status to engage in as a student, and they're going to be legal as a student, but if they go and do other things like work for you in student status, they could be illegal unless they have an employment card. So the only thing is, the only basic point is that it's the U.S. government is controlling the terms and conditions of residence under this temporary non-immigrant status. And you always know if someone is in temporary non-immigrant status because the designation is a letter-number combination. So whenever you encounter someone in a letter-number combination, in your mind should be going, okay, this means the person is here temporarily. What's the scope of this person's authority? So when you get into a business context, an employment context, this slide kind of addresses some of the major non-immigrant visas that pertain to the business community, okay? And we're going to be talking primarily about the H1, because that's kind of the workhorse, but then we're going to be going on and talking about a range of other business-related visa status, which can be used in order to meet your staffing and your employment objectives. So we have the visa options to consider, this menu, which is on the slide here, and then kind of breaking it down a little bit more into some conceptual parameters. Some visas are kind of restricted to certain countries. So you've got the NAFTA visa, the TN, or Australia, or Chile and Singapore. I'd love to be the fly on the wall when that was negotiated. But they have their own visa category, which is quite useful given the challenges within the H1B situation. We really want to talk somewhat about a new development for F1 students who are engaged in the STEM disciplines, science, technology, engineering, and math, as providing some really useful and potentially very beneficial pathways for you to recruit into your own organization very, very skilled individuals. And then there have also been some developments in terms of the ability of an H4 spouse. I think Deborah's going to be talking about that, to gain employment eligibility. And if I might just add one thing, parenthetically, I lived, 4 years in Russia, and my expatriate experience, really kind of picking up on what was said before, is there's oftentimes such a disparity between the principal spouse who's working and growing and engaged in a structured environment and the experience of the dependent spouse who may not have employment authorization. And that's something I think to really be aware of in your recruitment and staffing plans. Okay, we're going to start with what has traditionally been the workhorse of temporary non-immigrant visas for professionals, and that's the H-1B. In its essence, what H-1B is a temporary visa that specifically applies to foreign professionals working in professional level positions. So the essence, in many ways, is to define that the foreign national is professional, largely based on educational attainments, and is going into a position that is directly responsive to that professional credential. And in addition, there's also labor market protections, so you have to show that the position, the payment, the salary, compensation for the position is at a satisfactory level. So for years and years and years, and actually to this day, American employers have looked probably initially to the H-1B as their visa of choice. It can normally be obtained in a relatively short period of time. It gives a relatively generous period of employment and immigration, employment authorization and immigration status. It could be up to 6 years, in some instances even longer. And, you know, given the fact that the disproportionate, not exclusive, but the disproportionate need for foreign nationals will be in professional level positions, the H-1B becomes a very logical and desirable type of a visa. There's a little problem. There's a little hiccup to this visa category, and that is that there is as I'm sure just about all of you know, a limitation. That is, there are only 65,000 H-1B visa numbers available in the system. It's supplemented by 20,000 additional visas for advanced degree professionals. And the demand for H-1Bs is significantly higher than the quota allotment. So what you have is April 1, the application season opens. Employers put in their H-1Bs, and over the last several years, the quantity received is vastly in excess of the number of H-1B visa numbers. The chances are just statistically, about between 1 in 3 and 1 in 4 of being selected. So, you know, everyone, you know, applies for the visas for the H-1B. It goes into a lottery. It is chosen as initially on a random basis, and then if you're selected in the lottery, the U.S. Citizenship and Immigration Services will go on and make a substantive adjudication. Does the person meet the H-1B standards? So it's really, you know, a pretty unpredictable system, and it's an expensive system. I mean, the filing fees are in excess of $2,300, in addition to attorney's fees. So the thing is that because of the numerical limitations, if you're subject to the cap, H-1B has gone from a very convenient, predictable type of a visa vehicle to one which is really quite unpredictable. And what we've, in addition, found is that the service is kind of cracking down, particularly in the IT world, in terms of challenging is the position itself, what's known as a specialty occupation. Is the position itself requiring the services of a university-trained professional? And even if so, does the foreign national possess the responsive professional requirements for that position? So things which, at least in my own mind, seem kind of intuitively obvious, that a degree in mathematics is probably a pretty good background for a software engineer, is something which is becoming another flashpoint, an issue being challenged. Well, what does that require? It requires really quite, you've got to be very specific. You've got to be very thorough and exact in terms of the types of petitions being submitted. in addition, there has been a restriction in terms of third-party placement. So what immigration has injected says that if you want to sponsor someone for H-1B, you have to show that you actually control the employment of the foreign national, that you're the employer who is overseeing the day-to-day activities and is responsible for the activities of the foreign national. Well, you know, that's becomes quite challenging to job shops, and actually it becomes quite challenging to a broad range of employers that use either third-party entities for their staffing needs, or simply have a corporate structure in which they may not have, you know, it's not palpably obvious that they are supervising the foreign national. Again, none of these in and of itself becomes insurmountable barriers, but looking at the landscape, it's things that need to be considered and addressed in terms of the H-1B, putting in an appropriate H-1B visa petition. So, in terms of the requirements, you know, we've talked about the fact that the foreign national needs to have a bachelor's degree in the area of the prospective employment. There has to be the control issues, and you really need to address any type of third-party placements. And in a way, the H-1B is an ongoing contract between the employer and the U.S. government, where you have to explain what the person is doing, where they're going to be working, the terms of their employment, and so on. And to the extent that there are deviations from the original game plan, that may or may not require an amended filing. And that is something which I think you probably need to get legal advice in terms of, you know, I mean, positions are organic. You know, you sponsor someone assuming that they're going to be working in duties A, B, and C, but over time, there's a requirement for them to be working in D, E, and F, or whatever the growth is. And it's sometimes there's kind of this organic growth that an initial H-1B petition will cover promotions and certain changes. At other times, the changes become so stark that it requires an additional filing. But again, that is something which needs to have some rigorous analysis. Yes, please.
What happens if somebody has an H-1B with an employer that gets acquired by another company?
That's a great question. The law is that if there is a total acquisition, so not just of assets, but that the acquiring company becomes the successor in interest, then the H-1B rolls over. If it is something less than that, and you know, one of the things, and I think this really kind of pervades so much of immigration law. You've got business needs and how the business community works, and then you've got a somewhat non-responsive both bureaucracy and the law itself. So sometimes they don't mesh. And my only point is, in the acquisition area, immigration has created a very, very high level of showing that there's a successor in interest, which probably does not mirror how acquisitions are normally made. So as a statistical matter, many, many, many acquisitions, which seem to be a rollover, require requalifying for the H-1B.
I'll just make a note on that there are ways, if you know, for a structure. So a lot of the difference is a stock acquisition versus an asset acquisition, where you want to avoid liabilities. And there is a way to take your liabilities only for immigration, even if an asset purchase, as long as you affirmatively agree to do that. So unfortunately, as immigration lawyers, we're usually the last to know about mergers and acquisitions. But if you know this is coming down the pipeline, or you're buying out a company, it's fantastic to get us talking with your deal lawyers or in that viewpoint, because you don't want to buy a company all excited and then you realize you lose half the workforce because they can't, or you've just incurred an incredible expense to you to now file amended petitions for a whole group of people. So there are ways to strategize at the front end that can help make this easier for you.
Right. Okay. One of the cutting edge issues is you've got this demarcation line between H-1Bs that are subject to the quota restriction, so they're called cap subject, and those that are exempt. And I just want to spend about 2-3 minutes talking about basic concepts of exemption, because realistically, if you can position a case so it is exempt from the H-1B cap, in many instances, that's going to be your key to success. In fact, that's going to be the determinative factor as to whether or not the H-1B is going to be approved. So who and what situations are exempted from the cap? Well, first of all, you have certain employers that are exempted from the cap. Universities, that's the easy one. You're either university or not. Then the law creates an exemption for entities that are nonprofit and university affiliated. And here again, a little bit like the acquisition situation, immigration has come out with exceedingly restrictive guidelines as to what constitutes affiliation. There's this notion of shared ownership, common control. In other words, they've taken Wall Street concepts and engrafted it onto the academic community. So affiliation normally does not involve shared ownership and common control. It's more of a conceptual, philosophical relationship memorialized in an affiliation agreement, and yet that is not usually sufficient in and of itself to show that there's going to be an exemption based on an affiliation. So you've got teaching hospitals and all types of entities that have relationships with university institutions that are still left out in the cold. In addition, there's nonprofit research organizations and governmental agencies, fairly narrow. Then there's also going to be situations in which there's something called concurrent employment. So let's say that you have a relationship with a university or with an exempt organization. If they hire an H-1B, sponsor someone, even fairly de minimisly, 5% of the time, they can file their H-1B exempted from the cap. Once their H-1B is approved, a for-profit company engaging in concurrent employment picks up the cap exemption. So you could have conceivably a 5% employment relationship at the University of Minnesota, 95% employment relationship with a cap normally cap subject employer, and that cap subject employer picks up the exemption from the university. And again, this is something a little bit analogous to what Deborah's saying, with some advanced planning, with some communication, that might be something that can be considered. In addition, depending on the nature of your business, there is an exemption if ABC company, for profit, hires someone, but the foreign national is working at a qualifying exempt institution, like a university, perhaps in a lab, perhaps on the physical premises of the campus, and you can show that the foreign national is contributing to the educational or research or scholarly mandate of the institution, then that would also be conceivably cap exempt. But all of these, it's a fine line on walking through to determine cap exemption. But again, I want to stress, this in many instances is going to be the determining factor if an H-1B gets approved or not. Okay, want to talk any questions on H-1B? Because again, that's the workhorse of the system. Okay, I want to talk just a couple minutes on F1 students. So the United States is still actually statistically by far the most desirable country for foreign students to come. And the predominating visa that lets foreign students come to the United States is an F1. And it says that someone can come and study on a full-time basis. It does not create in and of itself employment authorization. But here you've got students acquiring really interesting professional skills, academic skills, which conceivably are very valuable within your own organizations. Well, there are a couple instances in which an F1 student can work. Number one, there's something called CPT, which simply says that you have a position that the admitting university recognizes and as containing educational content, and that the university will grant internship credit. So it's kind of an internship type program. The nice thing about CBT is you don't have to do just about anything. All of this is done through the university, through the Foreign Student Office. Then there's a program that says, normally it's following graduation. Once a student completes his or her studies, there's something called optional practical training, or OPT, and many of you, I'm sure, have hired students under OPT. And what this says is that the United States immigration authorities give employment authorization in order to gain real-world experience in the area of the academic studies. So it's a work card initially granted for 1 year, which can give first of all, a student the ability to get a job that illuminates their academic training. But number two, it's a great way, again, for you to hire someone with minimal involvement because they already have an employment card. Now, the advancement we've seen over this past year is that effective this past May, there's an expanded program, and it says this: if a student graduates, holds a degree in a STEM discipline, science, technology, engineering, and math, they have a potential for not only getting the initial 12 months of optional practical training, but 24 additional months of employment authorization. And that's called STEM OPT. The nice thing, when you think about it, is you've bought yourself 3 years of employment authorization where you can employ someone, which, number one, can create a window of time to sponsor them for H1B. You can go into the lottery a number of times, therefore, statistically increasing your possibility of approval. Or, in many instances, you could even sponsor someone for permanent residence successfully within a 3-year period of time. But STEM OPT has a couple hiccups to it. Mainly, two of which I want to just cite very briefly. Number one, you've got to be an E-Verify employer. So the E-Verify aspect only goes into effect on STEM OPT, not for the regular OPT. Number two, and it's not a fiction, but it's a reality that in order to sponsor someone and gain someone's employment authorization under the STEM OPT program, you have to develop and implement a training program. So there has to be this underlying structured element of training within your own employer situation. It can be done. You just have to kind of conceptualize the duties of the foreign national to incorporate some type of a training component. But the STEM OPT can really be very, very powerful. Please.
Fine detail about this. When a student gets a CPT or an OPT, and they get employed by a company and they get paid, don't they have to have a social security number in order to process payroll and all the other things?
Yes.
Into the system, so to speak.
But that is correct. But the attainment of employment authorization allows them to get a social security number. So they have the documentation allowing them to get the number, correct?
But it's just a temporary one, or it's actually?
No, well, you know what it is? That's a great question. The number itself becomes current. So once someone gets a social security number, that's their number. It's just that it's a little bit like a spigot. It turns on and off. So they'll have the number, but it becomes invalid if they lose their employment authorization. Please.
So the CPT is all sort of student-driven and university-issued.
Correct.
With the OPT, the employer doesn't have a lot of involvement in that.
No. And actually, it does not know, because what happens is the student gets the permission from the Foreign Student Office, so they are basically registered in the immigration system. It's called SEVIS, as being eligible for OPT. Then they file to the Immigration Service to get their employment card. Once they get their employment card, they can walk in, and they have a document allowing you to complete an I-9. So when you think about it, your involvement is absolutely de minimis. It's a little bit more under the STEM OPT because you have this notion of having to create a training program.
But
Yeah.
that's it, right? I mean, like, other than, like.
Yeah, that's pretty much it, yes.
Okay, yeah.
Okay? You want the clicker?
Yeah.
Oh,
You want to?
you just skip over.
Okay. Just to tell you, there is on top of that, Katie, all you have to do is there's also an annual review you have to do of your employee, and you do have a compliance rule. So if the person left your employment, you do have to notify the DSO that they're no longer employed with you. So it does create a little bit of extra work from the employer, but pretty de minimis. So, okay, here we go. Very good.
So I will talk about alternatives to H1B. Like Bob said, the new STEM OPT rule definitely relieved the stress for a lot of companies who are trying to recruit and maintain foreign workforce and who can't get an H1B through the lottery system. There are definitely a number of options for candidates, and we have to assess their eligibility for any of these on a case-by-case basis. And oftentimes when an employer finds out that, oh, I have, say, 50 or 100 employees who didn't get into the lottery, now what do we do? And a question that we're often asked is, can we bring them in on business visitors? Or rather, we're sometimes asked, well, we have this guy here on a B1 visa. Can we hire? Can he work for us? So the first thing to emphasize is that business visitor visas, or for people of certain nationality, they come in under a visa waiver program, so they don't actually have a stamp on their passport, and they enter with what we call ESTA, electronic system of travel for travel authorization. So for these people who are categorized as business visitors, they're not authorized to work in the U.S., so they can't be paid or receive any compensation from within the U.S. And the time period that they are allowed to stay in the U.S. is temporary. So for B1 visa holders, that's up to 6 months. Sometimes it's shortened to a month or 2 months, depending on the CBP officer at the border. And for ESTA visitors, it's up to 90 days. So for business visitors, the type of activities they're allowed to engage in the U.S. is limited. It's the typical business visitor activities like attending meetings, going to conferences, trade shows, and conduct contract negotiation, and that type of things. So if a good question to ask yourself when you think that, well, maybe this person is going to do something that crosses line, is to ask, would I pay a U.S. worker to do type of work or type of activities that this person is going to engage in the U.S.? And if the answer is yes, then you probably need work authorization for the person. And also, what's the risk for the company and for the business visitor for crossing that line? So one, the visitor themselves, if the CBP or at the consulate, they look at his travel history and realize that, oh, this guy has been traveling to the U.S. quite often. He just spent 6 months here, and he went to Canada for 2 days and come back, and he's trying to come back in. There's a good chance that at the border they're going to suspect that he's actually engaging in employment in the U.S., and they might either turn him away or they might give him a very short period of stay for this particular entry and tell him, listen, you need to get the proper type of visa to come in next time. And for companies, sometimes we see that certain consulates might flag a company if they see that this company is bringing in an awful lot of business visitors every year. And that might jeopardize your future true business visitors who are trying to get a B1 visa to visit you. So what are the good options that actually will allow a foreign national to work in the U.S. The first one we'll talk about, if I can figure out how to use this.
No, you have to use the clicker here, but it doesn't.
Which one? Oh, it has to. Oh, okay. So the first one is called J1. A lot of you guys might have heard of it in the context of a cultural exchange student, especially for people who work with universities. This is not limited to visiting scholars. For companies and businesses who are trying to bring in a foreign national who has a foreign degree and work experience abroad, if I can speak today, this might be an option for you. So there is a really informative article in your material today from a American Immigration Council about J1, so I won't spend a lot of time on it. The things that I want to point out is that for J1 trainees or interns, they have to have a foreign degree and work experience or work experience abroad. It doesn't necessarily work for someone who's already in the U.S. who is running out of OPT. And when you apply for a J1, we have to develop a training program that encompasses all the activities that this individual is going to engage in with your company. And there is and if we get it, it usually gets 12 months or 18 months for the individual to work or be trained at your company, which sometimes wins the candidates some time, and they might be able to try for another H1B visa next year. One catch for this category is that some individuals from certain countries and in certain fields are subject to a 2-year home residency rule, which means that once they complete their J1 program, they have to leave the U.S. and spend 2 years in their home country. This rule is put in place to actually protect high-skilled workforce for foreign countries. So the Department of State actually negotiate with certain countries to come up with a skill list. And they put it up so when you have someone who you're considering to get a J1 visa, we have to look for the skill list for the country that they're from and check whether his occupation or his area is on the list. If it is, then he is or she is subject to the 2-year home country rule.
If I can just put one additional word in, J1 is in many instances quite overlooked, but it can really be very, very useful because there's a level of flexibility to it. So, for example, I mean, if you've been to Valley Fair, if you've been to Disneyland, and you notice people speaking with foreign accents, a lot of them are J1s because there's a program that lets that type of exchange. And J1s go everywhere from, people administering the rides at Valley Fair to nuclear physicists at Harvard. I mean, it's this wonderful kind of malleable visa status. I'm going to just put in a plug. Years ago, I wrote an article, and it had my favorite title of any article I've ever written, and it's called Zila Gets a Visa. And if any of you remember the old Woody Allen movie about a guy who just changes into his environment named Zelig, I thought it was really a cute title for the J1 article. Okay.
Quick question. Is there any limitation to what type of company can utilize J1s, H3 and everything else? You have to have a certain number of employees or revenue or anything?
No, what happens is the
Actually, there are. So you need to have a sponsoring agency.
Right.
And the sponsoring agency may have rules on size limitations. If you're a small company, they have certain revenue, they have a certain number of employees. If you don't meet their threshold, they may do a site inspection in order for you to qualify to be an employer that can have sponsored Js. So it really just depends on the type of program you're using, intern or trainee. It's very specific from that avenue.
Correct. So the hierarchy is the Department of State runs the whole J1 program. Then they designate appropriate J1 sponsors, so they kind of farm it out. and it could be an individual company, in which case you have to have, I think it's 25, there you do have to have certain sizes in terms of the volume of your J1s. Or, as Deborah said, they kind of deputize other agencies, which in turn is responsible for the integrity of the end user.
So this gentleman mentioned H3 trainee visa. Even though it's also called a trainee, it's very different from J1. It's not reserved only for people with a foreign degree and foreign work experience. It's also employer-sponsored, more like a traditional H1B visa. So for this type of visa, it's for maximum for 2 years, and the amount of time an individual spent in H3 status would count towards the 6-year limit for H1B if they end up getting an H1B in the future. So for this type of visa or status, we also have to develop a very comprehensive training program for the individual. We have to be able to make a case that the content of the training is not available outside of the U.S. So it could be that the person is learning about a technology that's only available in the U.S., a type of processing, a specific kind of machine, or even U.S. law and regulations that's not available outside of the U.S. As an alternative to H1B, it's usually more useful for companies that have a significant international presence. The reason is that we have to be able to show that the training in the U.S. that you provide for the candidate will be beneficial for them to pursue a career abroad. So if you have, say, international presence, and the plan is for this individual or these candidates to go to a different location for your outside of the U.S. to work for your company, then this would be a very helpful. This might be a category that we can consider. And as the slide says, educational component is central because this is supposed to be a training program rather than work. So the USCIS will look at how much time is this program involves lectures, involves observations, how much on-the-job training it is involved, and it does not allow actual work, but only on-the-job training that's incidental to the education component. Oh, there we go. All right, so next one. Is O1 extraordinary ability. And we have a live example here in our audience today, so I feel like I don't really need to say much about it. If you have a candidate who's like Struan, or as successful as he is, then think about O1. If you have a candidate who's half as successful, we might still be able to make a case.
You want to say Frederickson did miracles.
So this category is intended for people who are well known in their industry, who has made significant contributions to their company, to the industry they work in, or even on a national or international level. So it doesn't have to be people in the business world. It can be scientists, researchers, even artists and athletes. Of course, with the new rules for STEM OPT, a lot of scientists and researchers might not need to consider this category. But if you have someone who doesn't fall under the STEM OPT rules, then this would be a great place to look. And it's usually what we consider someone extraordinary ability. We look at, has he or have they done something significant for their company, significant for their industry? Has their work been influential? Have they published articles, or have they been interviewed or quoted in the public media? Have they won awards? Are they holding leadership or critical roles in the organization they work for? Those type of things. So, and sometimes this is a category where we can definitely be a little more creative. And Deborah's nodding because she's very good at putting in the creative touch, and we have definitely brought some candidates to the U.S. under O1 status who you might think at first as a stretch, like executives or managers for startup companies that are not very well known. And Deborah probably can give more examples. So this is definitely a great place to look.
I think she means I'm good at BS, so let's...
So the last type of visa that I'm going to talk about, a lot of you might be very familiar with this, especially for companies that have international presence. It's L1A or L1B for international company transferees. It applies to individuals who are who holds executive managerial positions, or an employee who has specialized knowledge about the company's business that's not very easily transferable to other employees. This type of visa, of course, we will look at it if you're bringing in a foreign employee who has worked for your company, your affiliated parent or subsidiary companies abroad for at least 1 year out of the past 3 years. But sometimes if you have a candidate who's recruited from the U.S., but they either run out of H1B or run out of OPT, and if it makes business sense, sometimes we would recommend sending this individual to your affiliate or qualifying entity abroad for a year, and then bring them back on an L1 status. So there is similar to H1B, L1A candidates who. So these are people who are executives or managers. They can stay in the U.S. for up to 7 years. And for L1B, they can stay for up to 5 years. But there is an exception for that rule, which is for individuals who travel quite a bit. If they, especially for executives and managers, if they only accumulate about less than 6 months in a calendar year in the U.S., then they're considered intermittent Ls, and they're not subject to the maximum year rule. There are, so the process of getting Ls, of course, it's very similar to H1Bs. You file a petition to the USCIS first to qualify them, and then the individuals usually will need to apply for an L1 visa abroad at a U.S. consulate. There's an exception for Canadians who don't need a visa to come to the U.S. So what they do is they bring their materials, they apply directly at the border before they come into the U.S. There are also a type of L1 called L1 blanket petitions. This is for international companies that have very significant presence in the U.S. And what it does is that you apply to the USCIS without linking the petition to any particular candidate, and you ask the USCIS to approve your company as a qualifying entity. And then in the future, when you do have candidates from your affiliated or qualifying entity abroad who need to come in, they will directly go to the consulate to apply for an L visa under the blanket visa approval that you already have received. So with that, I'm passing this to Deborah.
I have the clicker. And I will be short. I've been told to be done in 10 minutes, so I'm holding you up for a break. So I will talk fast. So I'm talking about treaties. So we had mentioned before when nationality matters. So you're always told, you can't discriminate about national origin, but I'm here to tell you it's actually very important where you're born, because your citizenship can actually give you the right to work in the United States. You have a benefit that others don't. If you're Canadian, if you're Australian, if you're from Mexico, if you're Chilean or Singapore, you are lucky because we had a trade agreement with your country that's giving you additional rights. So I'll just talk briefly about them. So when you're screening candidates, it is helpful to know if they're from Australia, because while there is a limitation, they have never reached their cap. And so they can apply directly at the consulate for what's very similar to an H-1B, professional worker, pay the prevailing wage. They can apply directly at the consulate. We've had excellent success. In my opinion, it's pretty straightforward. They have revised the rules to make it a little better. When they created this category, I say they messed up. They forgot to include a provision that you could extend it in the U.S. to continue working. Everybody else within the regulation for most non-immigrant visa categories, when we extend your status, while it's pending and taking forever, and our later talk will talk about why it takes forever, you have the right to continue working in the U.S. for another 240 days. They forgot to include the E3s. So what did that mean? You had to get on a plane and fly to Australia, get a new visa, and come back in. That would also include your kids and family. Finally, they did correct that this year, so they now can file for extensions in the U.S., which is a big plus. Chile, Singapore, again, very similar. What's also unique about is allows for spousal work authorization. So important. I don't know how many Chileans, Singaporeans you're able to recruit, but something to think about if you get lucky. Like I said, quick. NAFTA. I'll talk a bit more about NAFTA because this is something we're filing constantly, and I think being in Minnesota, we get a lot of Canadians, and we get a lot of qualified candidates from Mexico with professional degrees that companies are eager to have. So a few things: you have to be Canadian or Mexican citizen. Spouses don't; they can be from anywhere and still come in as dependents. There is a list of occupations in NAFTA that's published. You have to fall into one of those occupations. Let's remember when NAFTA was passed, because even I can think back at least 20-some years ago, how many new jobs and occupations I've created that didn't exist when NAFTA was around, right? Pretty much our entire IT industry. So while you may have a job and you're looking at it going, well, my job says software engineer and you only say engineer, does it qualify? We would argue, hopefully, yes. So the idea is to craft your job description, create it to fit into one of those occupations. We try to be as creative as we can with what the legal parameters require. We've done one for an audiovisual sales marketing with a degree in architecture to fall under architecture because she's going to market it in sales to architecting companies. I've done an interior designer for Ethan Allen. She had an Etsy blog and website for years, and she had the qualifying experience. So you can be creative in who can qualify for these occupations. So don't get scared off if you don't initially see it in the list. There are some avenues we can still use to make that work. Canadians can apply directly at the border. And if you're unsuccessful, say you have a tough border entry, the good news is you can try again at the service center. So you actually can have 2 bites of the apple. If you weren't able to convince Customs and Border Protection, maybe you're going to have a better shot with the U.S. Immigration Service. So there are ways to kind of keep fighting these types of cases. For Mexican, they do have to file at the consulate. What's nice is they got rid of, you used to have to file the I-129 form. They got rid of that. It's similar package that you prepare for Canadian, except they have to go to, it's almost a 2-day interview. The first day of biometrics, the second day they actually have an interview at the consulate. For Mexicans, the harder part is they only get a 1-year visa. And why is that problematic is because when they need to renew their visa, they have to go back home. We also see a lot of issues with Customs and Border Protection making mistakes. So even though their visas for 1 year, their work authorization for a TN is 3 years. But what we see coming in is they limit it to 1 year. And so those are things to watch for and monitor. But good news, there was just some minutes that CBP released that said they're now going to have a proper procedure for documenting if you work a TN for multiple employers, that is going to be allowable. Maybe none of you want to tell your employees that, but say you have a part-time TN worker and they want to work for someone else, they can have a TN authorized to work for more than one company. They also have now stated that they can enter on their old visa with a prior company with a new letter of employment to change employers. That's new. It's one of those things we had always been a little hesitant to advise on. The hard part is if your visa is only good for 1 year, you may not always have that possibility, but it's something to keep in mind. So if you're worried about the H1B cap and you're still looking at recruitment, recruiting for Canadians and Mexicans is still a good option. Ease. This is helpful if you work for a company that is owned by either the majority owners are from a treaty country, so say they're owned by people from the UK, or your parent company is a UK company. That allows you to send over anyone who's also of that same nationality into the United States. The catch is that we have to have a treaty with that country. Of course, the most populous countries in the world we do not have treaties with. There's nothing with China, nothing with India, nothing with Brazil, but we do have one with Iran. So go figure. It's something to keep in mind. E's are filed at the consulate. You can do the U.S. Immigration Service. I would say 98% of the time we file at the consulate because you could get up to a 5-year visa. That's huge, right? What other visa category can we think of? You get 5 years. But what happens when you enter the U.S., they give you 2 years of work authorization. But if you travel the day before it expires and come back in, you just got another 2 years. So it's extremely useful. It's only for those who are executive managers or essential workers of the organization, and you do have to have that qualifying treaty. Spouses can work, so it can make the integration of the family much easier because they're going to have work authorization for any company. And it's really good for entrepreneurs, people who want to do startup. I've done a lot of MBA grads who have great ideas for starting up a company, and if they are lucky enough to have an e-treaty and some type of angel investor or to help them get the startup funds, that may be enough to get them on the ground to start exploring their dream. You can have minority investors, so we've had people with U.S. citizen friends who they want to own the business with them, so you can have a combination as long as we show the control of the entity, which is easiest done through 51% ownership, is governed by that foreign national. So great option. To keep in mind, the TN and the E, actually all of these treaties have what we call temporary intent. They don't have dual intent, which you see for the H and L, which means they are not supposed to also want to be going down that green card path at the same time. It's a conflict of intent. And so at the end of the day, a lot of people do want to go down the green card path. So that's something to work out when the timing is right, because it may require them to be grounded in the U.S. for a period of time, but it's still a possibility. H2s, we do a lot. Lon does a ton of these. And these are going to be for what I think, really temporary workers. So they can only work for you for less than 10 months a year. We have a large practice with this with the hospitality industry, landscaping industry. So these do not have to be, these could be unskilled workers. You could require someone to have a high school degree and the ability to lift 50 pounds, but you need 100 workers for summer because they need to plant, 10,000 trees, and this is your growing season. This would be the type of possibility. You need housekeepers. It's a complex process. It's almost like filing for a green card. You have to conduct recruitment and show you can't find U.S. workers. You have to file with the Department of Labor to show you're going to be paying the wage they tell you to pay. There's a set period of time before you can start the application to when you can file the application. You have to show that you've told all your other U.S. workers who used to hire for you that the position's open. You have to pay for everything. You pay travel costs. You pay their airfare costs. You pay for their trip over. You pay for their trip home. So it's a big investment by the company to do an H2, but it's also, there's only 66,000 visas a year for this category, and they're also always used up. What does that tell you? We have a tremendous need also for unskilled labor in many industries have a hard time recruiting. And so this is a very solid avenue. What we found is a lot of people had used that J1, the summer program that Bob had mentioned, but it turns out it's hard to train workers every single year, right? A whole new skill set. If you could get these same workers to come year after year, or you could keep them longer and maybe expand your duties, it's worth the investment. And so that's what we see come from a lot of companies. Okay, I'm almost done. Green cards, how does this fit, right? I'm teasing you. I just said this is all about non-immigrants. Well, what we talked about is sometimes none of these options are going to be a fit for you, and you want this candidate. We may have to either ignore the non-immigrant visa category and go right to a green card, or when someone's here on a long-term OPT and STEM OPT is look at trying to get the green card as fast as possible, as long as they're not from India or China, because not because I'm discriminatory, but because they're subject to a very long backlog, because that's going to be the fastest way for you to keep them. And at some point, it may be less expensive than trying for an H1B year after year after year. So things to keep in mind. And then finally, don't forget the spouses. So for H1Bs for up until a year and a half ago, that was it. H4 spouses had no ability to work. And what they've done is created a path for spouses of H1B workers to gather a work authorization document if the H1B beneficiary has an approved I-140 So really, this is impacting those in lower preference categories, beneficiaries from India and China who are subject to these backlogs, because we'll tell you eventually it could be 15 years for some people, up to 30 years, which is insane, but their spouse cannot be there if their marriage lasts that long, they deserve to work, right? So this provides a path where they can actually get a work authorization document because they're not able to file that adjustment of status, which would normally get them there. It's also useful if you have two spouses working on H-1Bs and one gets laid off. It can give that added safety net where the other worker could get a work card if one of them had gone down the green card path. L2s, E2s, again, I bring that up again, a benefit for these categories as spouses can work. And I bring up TPS as a humanitarian grounds. Recently, with Nepal, with Syria, we had a lot of high-level professionals and a lot of foreign students, I'd say, in Minnesota from these countries who, because of the terrible earthquake and the ongoing civil war, they're able to apply for temporary protected status, which allows them to get a work card. It's at no cost to the employer, but it's something your workers may come up to you or you may see this that can give them permission